All right. Hi. Good morning, everyone. Welcome to our webinar on legal implications of breaking a commercial lease. My name is Simon Reynolds. I'm one of the senior legal solutions consultants here at LegalVision. Obviously, thanks to everyone for taking the time for joining us. And I'm joined by my co-host, Paul. It's always a difficulty pronouncing Paul's surname, but Luciano, if I've got that correct. And Paul is one of our senior associates. He is a specialist within commercial leasing, absolute genius when it comes to absolutely everything you can think of with commercial leasing. So, yeah, we're in very good hands today, and really looking forward to what Paul has to discuss. So a couple of housekeeping points here for everyone. Just as a friendly reminder, everyone will receive a recording of this actual webinar, obviously, once we wrap up. Throughout the webinar, please do not hesitate to submit questions. Q&A, obviously, we will go through all questions and answers at the end of the webinar. We save a specific section for that. So if anything crops to mind, please don't hesitate to just pop some questions in throughout the webinar. And last but not least, please complete our feedback survey. We're always looking to improve our webinars, and we're always open to feedback. So please do not hesitate to put your details in as well as your contact information in, just as a friendly reminder, as we also are offering the complimentary consultation. Yes, on to my next point. So yeah, by viewing this webinar, everyone is eligible to receive a complimentary consultation with LegalVision, just so we can discuss your specific business requirements, what your legal gaps are, and obviously how we can support moving forward. So please, again, don't hesitate to put your details into the survey at the end of the webinar, or you can happily just jump on our website and put all your details in that way. Okay, so we've got a poll running. As you can see, it should have just popped up on your screen. So just the question is, which aspect of breaking a commercial lease is most important to your business right now? So just again, the question is, which aspect of breaking a commercial lease is most important to your business right now? So the couple of answers around this, pick or choose. Number one being understanding what a break right is. So firstly, understanding what a break right is. Secondly, how to properly exercise a break right. Or completing essential steps before the break date. Or key legal considerations after you break. Second to last, all of the above, or not sure, here to learn. So I'll pass to Paul just to crack on with the poll answers, but more importantly, just to dive into our agenda for today.
Thanks, Simon.
Thanks,
Let's
Paul.
look at the agenda, everyone. So we're going to be doing an introduction. We're going to talk about what a break right is. We're going to talk about how do you exercise a break right, what you have to do before the break date, key areas to be aware of after you break, and areas that aren't breaks but will act to end the tenancy. And then we'll have some Q&A. Before we do that, let's go back to the poll questions. All right, so we've got a lot of people wanting to understand the key legal considerations after they break, Simon. That looks like the most popular.
Is that, yeah, it does look like it, doesn't it? Interesting.
Excellent. And then the next largest is that people are here to learn. So that's great. And that's probably a good segue to kick things off.
Perfect. Thanks, Paul.
All right. So break clauses. Break clauses are extremely valuable to have in a lease, and even more so if you're a tenant. Without a break clause, A lease won't give a party the right to terminate for convenience. So what that means is the right to just terminate a lease early without a specific reason. If you didn't have a break, the landlord or a tenant would be forced to rely on their rights to terminate the lease for breach, or if you'd agreed to mutually surrender it. So different ways. If you're just starting the journey of looking for a premises, then a break clause is definitely something you should negotiate. And as a bit of a bonus, here are some negotiation tips if you're at that point in the journey. So if you're a tenant, preferably you only want it to be exercisable by you. So when you see that, when you're talking with agents, they'll call that a tenant-only break. That's what you want as a tenant. If you don't have that, and if they're throwing words around like mutual break, that means both parties can exercise. So obviously less favorable to tenants if a landlord can also exercise. You want to pretty much avoid break penalties if you can, though there might be situations where it's commercially viable to have a break penalty. A penalty is just kind of like it sounds. It's an amount you pay in order to break the lease. You want to make sure that the notice period that you're agreeing is standard. Market standard notice is 6 months, and we'll talk about that in the context of an actual break clause, but 6 months is the standard. And you want to try and place the break clause for the break date at a point in time in the lease where it makes sense, not just halfway through the term, which is what most people will do. If you're wanting the break clause because you're worried that you might outgrow a premises, you're not quite sure how your business is going to go, any of those sorts of reasons, then you want to position the break at the time that makes the most sense for you in terms of exercising it. You don't necessarily want to put it 5 years at a 10-year term because 5 years might be way too long in terms of working out whether or not you want to remain in the lease. So moving on, if you already have a break clause, then we're going to provide you now with some guidance on those things to look out for. So firstly, what is a break? So a break right is a mechanism in a lease for the landlord or tenant, or both, to terminate the lease early. And like I've already touched on, they're either going to be one way, so exercisable by either the landlord or the tenant, or they'll be mutual, exercisable by both the landlord and the tenant. And the most common here is tenant only, mainly because tenants are really the ones that need breaks. Most landlords aren't that concerned about having a break right. You'd only have a landlord break if a landlord had a very specific reason why they needed to end the lease early. Otherwise, landlords are quite happy to have the lease remain in place for obvious reasons because they're collecting rent. Break clauses will then also contain dates on when they can be exercised. This is called the notice date. And like I was saying, the standard notice period is 6 months. You see that in pretty much every lease. The times when it would vary is if you've got, say, a shorter term lease. If parties were agreeing, say, a 3-year lease, they wanted a break after the first year, you might agree a 3-month notice period because 6 months doesn't really make commercial sense. Equally, on the flip side, if you've got a very, very long lease, parties might need 12 months in order to find a new tenant because it might just be the nature of the land or the location that it's going to take a lot longer to find a replacement if the lease was broken. So, but 6 months is the standard. Then you'll also have a break that is the date when the lease actually ends, and that's called the break date. There's a few different types of break dates. So one of the most common is a specific date. So usually you'll have one date. So it'll be, you can break at this point in the lease, and that's either going to be defined very accurately. So it might say 23 September 2025, or it might say the 3rd anniversary of the term. If you've got the 3rd anniversary of the term, you have to do a bit of legwork when you're coming to exercise to make sure you've got that date right. But obviously, it's better to have a specific date if you can include that in the lease because everyone knows what they're looking at. It's not common to have more than one date, but sometimes that's negotiated. So if you've got a specific date, sometimes you might have one break, say at 2 years, another break, say at 8, kind of depends on how long the term is. So you do see that sometimes, but they would still be specific, so they're exercisable at that particular point in time. The other type of break, which is a little bit less common, is called a rolling date. So that's when effectively the notice period determines the actual break date, and you can exercise it at any point during the term. So it'd just be, you give notice, you give the requisite 6 months, and at the end of the 6 months, that's the break date. So that's how a rolling break would work. You might find with rolling breaks that there is a bit of a limit on when it can be exercised. So lease might say no one can break for the first 24 months of the term, and then either party can break or the tenant can break. And then finally, a break clause will also include conditions that need to be complied with for the exercise of that break to be effective. And there's some market standard conditions. So the market standard conditions are that the rent and other amounts under the lease have been paid up to the break date, that the tenant gives vacant possession at the break date, that the tenant's not in breach of the lease, that the tenant or landlord might need to pay a break penalty, or if you've got a landlord break, that the landlord needs to have the intention to redevelop. We'll talk about these in a little bit more detail. When I say market standard, these are the types of conditions that we see in leases most often. If it's a lease code compliant lease, and we'll talk about this in a little bit, but if the landlord needs to comply with the lease code, then some of these aren't lease code compliant. So we'll talk about how that changes. But these are the ones you see most often. So the other thing to note about conditions is the conditions can be required both at the point of exercise, or they can be required at the break date, or potentially both. It kind of depends on what the condition is and whether it makes sense. An example of that is you might find the requirement to not be in arrears of any payments, both when you exercise the notice and at the break date. But it's more common for conditions to be complied with by the time you get to the break date. That's the normal way that the leases are phrased. And the other thing to note here is that when I'm talking about conditions really attach to tenant breaks. So it's landlords will want to put conditions on how tenants exercise break clauses. On the other side of the coin, it's not common at all to see conditions on the exercise of a landlord's break if it just had an open break right. And that's largely because landlords have less obligations in leases, there's less things they need to do, and they're not in possession of the property. But if you've got a landlord break situation that's there for a specific reason, say the landlord has said in a few years' time they're looking to redevelop, then you might want to place conditions on that exercise because you might want to make sure that the intention to redevelop is genuine. So you might put that in as a condition, or you might have negotiated a break penalty because the landlord breaking is going to impact the fact that you will no longer have a lease. The other thing to note about break rights is that they will benefit successors in title. So what that means is the assumption is this applies, and unless the break clause is very, very specific to say that the clause is only for that particular tenant, so normally the tenant would be named, then if you were, say you're a commercial tenant and you look to transfer the lease to someone else, or if you're a landlord and you transfer the lease to someone else, then the break right would carry across as a right exercisable by that transferee. So they would effectively become the tenant and be able to exercise the break if it was still subsisting. Another aspect to cover off is what we've largely been talking about. This will apply to any type of lease, but where you can get a little bit messy is when you might have a situation where you're talking about subleases. So it's helpful to think of leases in sort of the conventional sense where you have a freeholder landlord that grants a lease to a tenant and that's it. You've just got that one dynamic. You can have situations where you'll have a freeholder head landlord are then a landlord who's a leaseholder. They then sublet to someone else. They might sublet again. If you've got that situation, there can be break clauses in all of those intermediate leases. And that there can be some overlapping considerations with those. But the normal position is that if a break is exercised in a head lease, the sublease would fall away. If there's an issue with that exercise, which we'll talk about in terms of defective breaks, that can cause all sorts of complications. So potentially the underlease will subsist, and then there might be problems with it going back up the chain to a superior landlord. Also, if they're protected tenancies, so if the 1954 Act applies, there can be issues with perhaps the break isn't effective to terminate the rights under the 1954 Act. So that landlord will have had to have ensured it complied with its statutory obligations to do that. So yeah, if you've got a more complicated situation like that, definitely preferable to get legal advice at the time. But those sorts of, that structure can cause issues for these things. So now we're going to talk about how you exercise a break right. And like I've been kind of alluding to, there's effectively, or at least this is the way I think about it, there's two parts to a break, really. There's the first part is issuing the notice, and that has its own set of requirements. And the second part is complying with the conditions. So if we turn to notices first, so notices need to be really specific. You need to follow the lease requirements as closely as you absolutely can. It strictly as possible. And this can include any notice periods. So when we're talking about the 6 months, you can't be 6 months and 1 day. If it says no less than 6 months, it needs to be 6 months. If you have conditions on the exercise of notice, then you have to have complied with those conditions. And there's also something that lots of tenants will overlook is very often in leases, there'll be a clause that's maybe titled notices, it might be called something else, but it will set out how notices are to be issued under that lease. And when it talks about notices, it will usually mean formal notices, which includes break clauses. Now, you might get a clause that's very, very specific. So it'll say, you have to serve it on this address. This is the deeming provision for when it will be received. It has to be sent by post. And as an aside, pretty much every lease these days will say fax and email aren't good notice. So pretty much every formal notice needs to be served by post, and the lease will say what type of post. Sometimes it just refers to a clause in a particular law called Section 196. If that's the case, then yeah, you're assuming service by post really is what that clause is talking about. And the other thing with notices is time is always of the essence. So what that means, that has a particular contractual sort of legal analysis to it. But for the purposes of breaks, it means that you really need to comply with any time-based requirements strictly. If you miss the time requirement, then you won't be able to exercise the break. You won't be able to rely on it. The other thing to point out about notices is you can't actually take a notice back once you've served it. So that essentially, if you're going to exercise your break, just have really confidently made sure you want to exercise the break. If the parties tried to negotiate to revoke the notice or anything after, then they may be creating a new lease situation. So effectively, the old lease is gone from the break date and a new lease will come up in its place. If the landlord goes to court to overturn the break, it's obviously going to change things, but the notice itself can't be withdrawn. And then turning to conditions. So largely this is knowing what you need to do and when, and knowing how to comply with those. We're going to talk about that in a little bit more detail now. But the thing that I wanted to cover off is something else that's key to break clauses that's quite often overlooked, is that break clauses will very rarely talk about all of the other things under the lease: repairs, decorations, reinstatement, all of those requirements that are expressed to be things that you need to either do throughout the term or you need to make sure you've done at the end of the term. Quite often what you'll find is the phrase end of the term is defined to include language that says however it ends. If it has that wording, if it's suggesting that it doesn't matter how the lease ends, then all of those things can be pulled in to the break requirements. Not necessarily as a condition of exercise, but as something that needs to happen when you actually break. So increasing liability. But it can be quite often a condition of exercise as well. So that's another thing to keep in mind. But let's turn to what you have to do before the break date. So this is talking about conditions. So if there's a condition, it needs to be complied with strictly. And there's a whole different buckets of conditions which we'll kind of go through. So if you're in arrears, then you need to have paid any arrears. And this is better to just pay things and potentially have an argument about it later, though we'll look at kind of a potential consequence with that. But if you owe money, any of the amounts payable under the lease, and the break condition is that you have to pay all amounts payable to the landlord to exercise the break, then you want to make sure you're paying everything. That might include like late payment interest, all of those things. You're also going to want to make sure that you're completing any repairs. So this is going back to that end of term concept. So end of term not just meaning the classic effluxion of time, which just means when the term was going to run out. So this can be reinstatement of alterations, which might be in a license to alter, not necessarily in the lease, and it'll include your positive obligation to keep the premises in good and substantial repairing condition. So that'll be something that you should have done and need to hand the property back in. And it can also include end of term decoration. So most leases will contain a decoration clause, and that decoration clause will say that you had to have done some end of term decoration in colours that the landlord assists in choosing. Another one that's quite often overlooked is most leases will have some level of compliance requirement. It might be explicit, saying you have to comply with all fire safety requirements, or it might be more vague in the sense that you have to comply with all laws that affect the premises. And that might extend liability to electrical safety, things like that. And if you're not handing the property back in that compliance state, then the landlord might have a claim for those. And then the last one is talking about vacant possession. So vacant possession largely means, we'll talk about a few cases in a minute, but basically removing all your property and people from the premises. So there's a few different examples of where this can be a sticking point. We might dive into it in a little bit, but essentially if there's something that's an impediment to the landlord taking occupation, then that can defeat the break if you were required to give vacant possession. So let's dive into a few of these. So key areas to be aware of after your break. So this is one that might come up if more so if there's a dispute over a break, but you might be arguing that these conditions were waived. So how does a waiver work? Well, in this context, you probably want to get waivers in writing. The lease might even say that any waiver needs to be in writing. And then if it wasn't in writing, you're having an argument potentially at court to say that there might have been a waiver by conduct. So were the parties doing things, principally the landlord, because it's going to most likely arise in that context, that suggested that this was waived. So the landlord, a classic waiver might be the landlord didn't require you to do some part of your repairing obligation, or didn't require you to pay all amounts, only amounts up to the break date, for example. If another one that can defeat a break, and just to sort of take a step back, when I'm talking about defeating a break, this is where the landlord might go to court and say the break wasn't effective to terminate the lease. So the lease would remain on foot. So you could have a situation where you thought you were exiting a lease at 5 years, only to find out that you've got another 5 years. And that's a pretty significant liability to be facing. So that's what we're talking about here with things potentially being defective. So leading into that, the other one is defective notice. So a defective notice can act to defeat a break. And the classic case example, which I liked saying, is this basically in passing, a judge said if a notice clause said that the notice was required to be on blue paper and you served it on pink paper, then you might not have actually given good notice. So it can be as strict as that, depending on what the clause says. And then coming back to that vacant possession point, so that can also overturn the break. There's been cases. The classic examples are if you had staff going in to do works after the break date, then that's a problem. If you left alterations that were part of your fit out, that can be a problem. There's been cases where this has gone both ways, where security personnel have been left in place because of the nature of the premises. Sometimes that will be a problem. Sometimes it might not. Depends on the nature of the premises. But all of those things are things to be aware of. And then failure to repair, we've kind of already talked about that. The other point I wanted to touch on in terms of rent and paying that is what a lot of tenants will do is they'll actually arbitrarily only pay the rent and other sums up to the break date. That can be a massive problem. So if the break clause doesn't permit that, and the rent is payable, say quarterly, service charge is payable quarterly, there's a presumption that you're paying the period that the lease actually requires. And that's what you would need to do. What you'd then be looking for, and you'd hope that you'd negotiated this into the break clause, is that you've got a provision that says any amounts that are paid beyond that are repayable. So they'll be refunded to you. That's really the way that you navigate those sorts of payment problems. If you don't have that provision, then unfortunately courts have held that there's no entitlement to a refund. So you would have to negotiate that position with the landlord. But you'd want to be paying all of the amounts you need to be paid because the risk of the break being challenged is higher than the amounts that you will have paid on account. And I know I mentioned before the lease code. So some landlords are regulated by the lease code and they set out limits on break clauses. So these are the limits. In terms of amounts that need to be paid as a break condition, it's only rent and it always needs to be repayable. They don't want vacant possession to be required as a condition, only that third-party occupation is not allowed, so no subleases or licensees. Break penalties are not best practice, although they can be permitted in certain contexts. And repairing requirements are not best practice, so having that as a condition. But like I said, most leases will be phrasing things like with that end of term language, which can still catch that. And just quickly, so I know the subject of this webinar is largely about breaks, but it's always good to talk about other ways the lease can end. So I just wanted to sort of cap that off at the end. The biggest area I think is obviously forfeiture. If you've never heard of forfeiture or you've heard of it as something else, this is the ability for the landlord to re-enter the premises, terminate the lease, and it often arises in the context of breach. The most notable breach that it arises in is non-payment of rent. And the most salient example you hear of is where the landlord has just used a bailiff to change the locks. Using a bailiff to change locks is lawful, provided that the forfeiture was lawful. So that's the first thing to note. There's a few different categories of re-entry right. And for the landlord to be able to do this, the lease does need to contain a specific right. If the lease doesn't contain that, it doesn't necessarily mean the landlord can't exercise forfeiture. It would just be far more limited in what it could exercise forfeiture for. But all modern leases will include a forfeiture clause. So that argument never really flies. So usually it'll say non-payment of rent or other amounts under lease, breach of the lease, and then talking about insolvency in either bankruptcy or corporate insolvency. In terms of non-payment of rent, the key thing to note is that no notice is required. So the landlord doesn't have to have issued an invoice for non-payment of rent. Usually this will extend to other amounts as well. They're just payable when they're payable. If you're paying service charges periodically, then the no notice could apply there. Otherwise, things like insurance and service charges, you wouldn't conceivably be able to pay without an invoice because you wouldn't know what the amount is. So you can have an argument over those. For other breaches of the lease, a precursor to forfeiture is the issue of a Section 146 notice or a 147 notice. That's when the landlord needs to give tenants basically a notice saying, this is why we think you're in breach. If the breach is capable of remedy, you should remedy it within a reasonable time. There's a whole host of requirements for those. But essentially, the landlord, if it just went straight to forfeiture without going through that step, that forfeiture could be wrongful. And I guess the consequences of forfeiture are pretty severe. So it will mean you're immediately not able to access the premises. If you tried to force entry, you'd be a trespasser. So all of your equipment and stock and everything is in the property, and you'd have to negotiate to get that back. And really your option there, the lease is at an end the minute the locks are changed or there's an order for possession. So the tenants do have the ability to go to court to recover possession, and a lot of the time that's granted, but it becomes a more expensive process. And if you're in arrears of rent, it can just spiral the issues. The other method is insolvency. So insolvency is a bit out of the scope of this webinar, but essentially when a liquidator is appointed, they can go through a process called disclaimer, which they basically say the company is not going to be bound by this lease. The landlord then gets forfeiture rights based on that disclaimer, but it'll all go through the insolvency process. And then the two other categories, one which I've left off the slide, but which I thought we should mention. But the first one is insurance. So damage by insurance can allow termination where the damage can't be rectified or it can't be rectified by the end of the loss of rent cover. So that gives termination rights. That's another way the lease can end. And then if you don't have a break right, you don't have any other way of getting out of the lease, a surrender might be an option. Surrender needs to be agreed by the landlord, and quite often, they'll require you to pay amounts. There might be a penalty to surrender. There might be paying their legal costs, paying their reletting fees, complying with all your obligations. So yeah, not the best option, but if it's the only option, then sometimes that's available. And those are all the points there. So I'll hand back to Simon.
Amazing. Thanks so much, Paul. That was super informative. And thanks for everyone for taking the time to listen in. Just as a heads up, we always do this. We've got our publication to download. That concludes the main part of our webinar. You might find this publication really useful. As you can see on the screen, just a QR code. It's a download landlord's cheat sheet for UK leasing terms. A lot of our clients find the publications we have incredibly useful. So yeah, find some time to have a good read through that. Again, if you have any questions now or down the line, don't hesitate to just pop them into our Q&A section. We can answer them at the end, or just submit your details through our website, and would love to get in touch. Yeah, obviously, you might be interested too in our next webinar. We tend to have more and more clients attend our webinars week in, week out. But the next one is going to be around funding your business legally. So equity, debt, and investor readiness. That's going to be on Tuesday, the 30th of September at 11 a.m. Obviously, if you're interested, please register your interest now just on the link as you can see on the screen. Cool. So yeah, I just wanted to take a minute or so before we move into the questions and answering that, just to talk a little bit more about our legal membership. So yeah, traditional law firms typically will charge per piece of work or on an hourly rate, upwards of £400 to £500 per hour. For a lot of clients and businesses that we work with, they tend to have more than just one thing that they need. We specialize a lot with startups, and they love our membership model. It's cost certainty as you're scaling. The more legal needs you have, the better. You can obviously utilize it as much as you need. So the legal membership that we offer is a fixed monthly cost, and you literally get unlimited commercial legal support. So we can help with unlimited advice consultations, document drafting, reviews, amendments, obviously commercial leasing, which is obviously led by Paul. But yeah, anything around GDPR, trademarking, cap raising, buying, selling businesses. We do it all. We're a one-stop shop. We're a full-scale commercial law firm, and you get access to over 100 specialist lawyers. So whatever you're needing, we can assist. And yeah, the membership is offered in different terms. If it's something of interest, we would highly recommend claiming your, complimentary legal health check. We can identify what your legal needs are, what type of industry you're in, and what your future plans are looking like. We can then discuss pricing and how we can support you best with regards to our membership. So please don't hesitate to jump on our website, put your details in, or on the survey. Please don't hesitate to put your details in there too. Cool. So yeah, just I guess wanted to pass to you, Paul, just to go through this Q&A. I know some people have submitted some questions. We also had some previous submitted questions. But yeah, I'll pass this back to you, Paul, if that's okay.
Yeah, great. Thanks, Simon. So
Amazing.
the questions that we have, I've got one saying, how can both parties, i.e. the landlord and tenant, be penalized for breaking commercial leases? I guess this question probably falls into two buckets. So if there is an actual penalty in the break clause, then that would be an express way that the parties are going to be, I guess, penalized in the sense that they'll have to pay a fee in order to break. Otherwise, it's going to more fall into the categories that we've been discussing. So for tenants, it's risk around non-compliance or things that they should have done. Remembering that for things like repairs, even if it's not something that would necessarily disrupt the break being effective, if you haven't done it, then the landlord could still have a claim for dilapidations. So that's a way that they could effectively be penalised. Landlords, far less sort of ways that they would be penalised for exercising a break, unless there was something very specific in the lease or they'd done something really, really bad to breach the lease. And then another question, so I hope that answers the question. Another question that we had is what to do if there's no break clause. So touched on this a little bit. There will be a few different options depending on what the need is. So assuming that the need is to get out of the lease, most leases won't otherwise include a termination right. So it won't say you can just terminate if there's no break clause. So you're kind of left looking at, could I potentially transfer this lease to someone else? Could I potentially sublet to someone else? So those aren't necessarily ending the lease per se. If you transfer to someone else, you might be required to give an outgoing guarantee, so you're not completely off the hook. If you sublet, you remain the tenant. But there are ways of managing the situation. Or there's that option to talk about to try and negotiate a surrender with the landlord. But like I said, that's only by agreement. The landlord can place conditions on it. There's no requirement to them agreeing. Yeah. Were there any questions submitted during the webinar? I think those are the only questions that I had. Oh, no, here we go.
You can see there's two here. Yeah, Paul, just
Yeah.
as a heads up, I think someone's just punched some in.
Yeah, okay. Let me just have a look. So, whoop. Yeah, so I'm a landlord and have a commercial tenant. It's not done so correctly. However, I have a tenant and Yeah, so I guess so that question there probably needs some legal advice on that one. Sounds like it's
Mm,
a little bit more of a more involved question, I think. So we'd have to take a look at the lease, and I guess assess the commercial reality of trying to challenge the break or coming to some other kind of settled outcome. And then another one that we've got is, do dilapidation repair obligations have to be fulfilled before the break date, or will the lease continue temporarily after that date until they're fulfilled? So it it depends a lot on what the break actually says. So if it's a condition of if it's a condition on the break, then it might impact whether or not the break is effective. But if the lease requires it to be done, then it is something that would need to be done before the lease is terminated. So that's like we were talking about before. So if the lease says all of these things need to happen, the end of the term means the end of the term, however it ends, then there's an argument those things need to be done. So you need to comply with your end of term obligations. In which case, yeah, you might, if they're not done, you might have a dilapidations claim as a landlord. And then I've got another question from this is a client of mine who asked, are there any plans on a repair dilapidations webinar? We'll have to stay tuned, I guess. Yeah, I'll float the topic and see how we go.
love that. Thanks so much, Paul. Yeah, that's pretty much a wrap, everyone. Thank you so much for taking the time to obviously sit with us today. And Paul, thank you so much for taking the time to run through all of that. Sorry if we didn't have enough time to go through any further questions. Obviously, if anything does come to mind specifically for your business, please don't hesitate to put your details in on the survey at the end of this webinar. We would really appreciate and value some feedback. So if you've got 30 seconds just to pop in some details, that would be great. But yeah, anyone that is wanting their complimentary legal health check, again, please submit your details through the survey at the end, or happily just jump on our website and we can book something in and discuss your legal requirements a bit more in depth. Kind of like Paul's first question there, clearly needing some legal advice with that scenario. Please book in a consultation. Would love to pull back the layers a little bit more and see how we can assist. Also, a friendly reminder with the membership, we also help a lot of businesses that have in-house counsel. We just operated on what we call a desk extension. We do a lot of that too with regards to our services. So if you do have anyone in-house, in-house counsel, we can assist further with that scenario too. But outside of that, thanks again. Obviously, this is a free webinar. Don't hesitate to put your details in at the end, and we really appreciate some feedback. So if you can find 30 seconds, that would be great. Outside of that, have a really great rest of the week. Stay warm. It's getting a bit colder. And if you need anything from us, don't hesitate to get in touch. Thanks again. Take care.